State of Florida in this honorable court.
Thank you. You may be seated. We have two cases on the docket today. The first case is Mastrandria versus Snow. Is the appellant ready to proceed? Thank you. You may.
My name is Jack Crumbine. I represent Roland Mastrandria, the appellant in this case. May it please the court.
Will you pull the mic a little closer?
Oh, yes. Do I need to repeat what I just stated, though?
Go ahead.
May it please the court. Would the court like to hear a brief recitation of the facts, procedural history, and how we arrived here? This
Well,
morning?
what I want to know is whether Mr. Mastrandria is a public figure.
Yes, he is a public official, a former public official at this point in time. We're not contesting the issue at here this morning.
Okay, so what's the standard for any kind of libel for a public figure?
Well, it's actual malice, Your Honor, or reckless disregard.
Okay.
And so,
Have you read some of the criticism of the New York Times versus Sullivan decision from luminaries such as Justice Thomas and Judge Silberman?
I have not. I cannot say.
They argue that that decision is completely contrary to the text of the Constitution, has no basis in the common law, and should be repealed, receded from. We can't do that. But I was wondering if you might have any thoughts about the deleterious effects of New York Times versus Sullivan as it applies to your client.
I do, to some degree, Your Honor, in relationship to the Florida Section 7.
Because basically under that statute, the media can make false statements about public figures almost with total immunity, as Justice Thomas and Judge Silberman mentioned.
Correct, Your Honor, and I think that what it really does have to do with, and I believe that I've read a little bit, and I'm not sure if my memory will fail me, but I think it was Justice Holmes that stated that it was the continuous evolution of the balancing test that had to be treated by the judiciary that continuously eradicates the First Amendment rights to freedom of speech in order for us to be able to live within ordered liberty. And so I think that that touches directly on the application of Statute 768.
Because here, there's no question that any comments by the appellee regarding insinuations of unethical or financial improprieties, those were false, right?
Yes, Your Honor, and I believe that in the record it actually speaks directly to the fact that she either knew they were false or simply disregarded whether they were false at all. There are multiple sections in the deposition transcripts that demonstrate to contradictions, later admissions to, for example, language being employed such as whether my client was working directly for the developer or first denials, then admissions.
And in fact, in this case, it kind of brings to an example of what Justice Thomas talks about in a dissent from certiorari denial, that actually libel against public figures is a greater harm to society than libel against private figures, right? Because
Yes.
here, for example, you can recklessly say a city councilman or someone's acting for financial improprieties or on that basis, and that causes disrespect for the actions of the public body, right?
That's correct, Your Honor, and I think that your point goes directly to Garrison versus Louisiana, 379 U.S. 64, 1964, where there was a publication made imputing crime on, I believe it was 8 judges, and the court stated that although speech concerning public affairs is more than self-expression, it is the essence of self-government, but it did limit it by stating that it does not follow that the lie knowingly and deliberately published about a public official should enjoy a like immunity. And use of the words, in that case, racketeer influences in relationship to the judges, suggested an imputed crime, an expression that the judges had enjoyed outrageous, for example, a vacation time, also suggested and connoted a violation of law. In that particular case, malfeasance, analogous to some of the accusations made to against my client for malfeasance and misfeasance, and
Right.
indirect.
For example, in this case, I guess the question is, the line is, Because, as Justice Thomas notes, even under the law at the time of the founding of the country, you could, obviously under the common law, typically of the states, you could criticize a public figure for public actions by that figure, but you couldn't falsely impugn crimes such as bribery or other immoral acts falsely. So let's look at the facts here. Now, summary judgment was granted, and the question is, your client was accused of financial improprieties by implication, that he was making decisions not based on the merits of the case, but on financial gain, right?
That's correct, Your Honor. And what was very interesting to see and is visible in the transcript of the deposition of the appellee is that the responses were highly evasive to that particular issue.
Right. You're right. The issues weren't, well, this development is a bad idea because it'll dump additional stormwater runoff. I mean, those may have been raised also, of course, I'm sure.
Yes, Your
But
Honor.
the issues were, your client is in cahoots with the developer.
Correct, Your Honor, and it was by implication. The responses were statements of fact couched in the manner of opinion. We had an avoidance of providing a direct response by using words such as "we," as if the deponent at that point in time was a representative of a group. We had.
So which of your statements are you alleging were statements of fact versus statements of opinion? Because a lot of them seem to be at least based in opinion.
Sure, Your Honor. And so some of the statements of fact that I see, for example, included, for example, record page 263, and it spoke to unethical behavior of my client in relationship to violations of sunshine law. And the fact of the matter is that the appellee admitted to those statements having been made, really not knowing whether they were true or not really caring whether they were true or not. In fact, there were multiple occasions throughout the record whereby the appellee stated that even if someone had explained to her that her statements were not correct or not based on...
I think her explanation was, she said, appeared to be, or emphasized appearance of impropriety. So in response to Judge Roberts' question, give us specifics with respect to where's malice? Where's the evidence of malice?
Yes, Your Honor. So on record page 276, deposition transcript 222, paragraph 23 through 25, page 223, paragraph 1 through 8, the appellee states that it would not matter if she had made false statements of fact that were defamatory related to ethics violations of the appellant. And I believe that that shows reckless disregard. I believe that if an individual, another factor with actual malice, Your Honor, is, for example, that she had the opportunity to interview my client to speak to the issues that she had concern with. She also had the opportunity to speak with the developer directly and was provided with a letter showing no financial interest, chose not to interview these individuals. That goes to actual malice, Your Honor, under the case law. So I think that when we look at the entirety of the record, we see that there is perhaps the appellee being entrapped by her own imagination and simply throwing out statements that because of that also fall within actual malice, or at least allow for that to be interpreted that way. Now, that would be under Hardy.
Do you attend a lot of city and county commission meetings?
I do not, Your Honor.
Because I used to in certain other jobs I had, and it seems like there's someone at every county commission meeting that basically stands up and makes allegations such as this against any and all the commissioners. And I guess that's unfortunate, but the New York Times versus Sullivan, whether you agree with it or not, that being the case, I don't know much that can be done about that.
Well, Your Honor, I think that the limitation is whether someone knew what they were saying was false, whether they had entertained serious doubts as to whether the statements were false.
Right, under New York Times versus Sullivan, the evil that has proceeded from that decision is a person can make false statements and not investigate, just hide behind a cloak purported ignorance and accuse people of all kinds of improper and unethical conduct, and the press has total immunity from making those kind of false statements, right? That's what Justice Thomas and Judge Silberman have commented on regarding New York Times. Now, we're bound by it, obviously, but we certainly can question it and how it applies to a person such as your client here, who's basically been accused of, by implication, bribery.
Correct,
That's
Your-
exactly what is at the crux of this matter here.
Correct, Your Honor, and there was a retaliatory letter that was sent to the Governor DeSantis' office just the day of the lawsuit, and in that letter, the appellee directly implied corruption, malfeasance, misfeasance, and in the deposition admits that there was no basis for that. So I
But
don't know how.
there are a number of people, you gotta agree with me, that there are a number of people that are so sure of the rightness of their position that if anybody agrees with them, it has to be because there is bad motive or ill intent. And they really believe that.
Correct, Your Honor, but I think that there's a difference between falling to your own imagination, to one's own imagination, which would be a basis to find actual malice, and having, for example, information from someone that would validate a position, and if that position comes from a credible source, then I think that there is, under the case law, an immunity to the statements made, but that's not the case in this case. In our case here. Now, the other issue for the court to consider is whether the Florida Section 768.925 actually applies if there isn't sufficient evidence in the record for the court to, for a jury to find actual malice at trial. And I bring this up because there are two issues here. We have a remedial statute that should be interpreted liberally. However, there are some limitations based on language because there are two sections. One, the statute does provide for some limitations such as primary purposes of a lawsuit filed, statements made before a governmental institution, but it also provides for limitation in subsection 2A, where it states certain literary types of works that are provided with the guarantees of speech. But the last little section there states other similar works, and other similar works is a broader language that requires interpretation by the court. However, similar works is the issue, similar to those enumerated works, meaning they really do have to be type of literary works. The libel count in this case was mostly based on emails, text messages, private messaging, and that cannot be constituting a work. Now, for example, I make the distinction in the sense that there is something called messaging. A meme, for example, thanks to Andy Warhol, perhaps we can call that an artwork, right? Because it contains a message. A tweet, properly crafted, contains a message. However, private text messages are simply the replacement by electronic media that would allow us today to replace oral communication, live communication, and that should be treated differently because it's not an other work. And so therefore, those types of communications would have to be made before a governmental entity in order for there to be protection, and there's no way that could have been the case. So that's why I argue that that particular statute, section 768.925, does not apply in this case with regard to the dismissal. Now, I have 2 minutes and 15 seconds, and so if I may go back, I know it's a little bit out of order, if I may go back to the issue of the record evidence. A particular
And
issue.
I don't know if you said you were gonna reserve any time for rebuttal, so but
May I
that's all your time.
May I reserve 2 minutes for rebuttal at this time?
Yes, you may.
Thank you.
Good morning, Your Honors. My name is Robert Aguilar. I'm here on behalf of the appellee, Sherry Snow. If it pleases the court, I don't believe I need to go into the question over whether Mr. Mastandrea is a public figure. I think we've decided, I think we all can agree on that. on that point. This is basically a suit that was brought by Mr. Mastandrea as a city councilman, town councilman, Orange Park, sitting politician, over objections to a pet project, a development project in Orange Park. He sent out, or his attorney sent out on his behalf, a number of identical demand letters. Some would call them threatening letters. Interesting because they were, in fact, identical except for the names of the addressees. All of them accused of making the same oral statements, all of them accused of making the same statements at the same time and under the same circumstances. Ms. Snow received one of those letters. She was the one who was sued. One of those people, Mr. Reese, whose deposition was filed in the court below, did apologize, a rather strained apology, which was quoted in my brief.
So why wasn't there enough evidence in the record that this shouldn't have gone to the jury?
Let's take a look at.
'Cause you have to agree that there possibly is some evidence, if believed by the jury, shows that Ms. Snow had reckless disregard for the truth or falsity of the statement she was making.
I don't believe so, sir, and I'll tell you why. Her entire deposition, which went over 3 days, and was reviewed by the court. As a matter of fact, the trial judge made the point of saying, I'm going to review this entire deposition. And she's asked the same questions repeatedly and gives the same answers repeatedly, that she was giving an opinion. She never said, as a matter of fact, she even said, I wouldn't even know what the words on the take are. I wouldn't use the words on the take. When she was concerned about Mr. Mastandrea working with or for the developer, her concern was that, as she says, very expressed several times, he would go to see the lenders with the developer. Why is he doing that? Why is he working with them? She said she never thought he was taking bribes, and she never thought he was.
You don't think that was a fair implication of her comments?
I think so, sir. I believe so, because working with.
Working for, working with?
A fair application
I
of
mean,
it.
isn't it up to the jury to decide what's a reasonable inference from those statements?
Your Honor, considering what are the other statements that I have seen in case law that did not constitute evidence of actual malice, it is, what she said is almost bland compared to things, the statements that have
Well,
been
yeah, I'm
made.
aware, yes, excuse me, I'm aware under New York Times versus Sullivan, the media is allowed to make false, reckless, outrageous statements against public officials with, quote, near immunity, as Judge Silberman noted, under that case that reversed 175 years of law with no grounding in the text of the Constitution, according to Justice Thomas and others.
I'm familiar with that.
But that is the binding law, fortunately or unfortunately, depending on your perspective. So is it your position then that your client could have actually implied that the appellant was acting on improper financial considerations?
If she had come flat out and said, let's take that as a hypothetical. If she had come out and said, and a lot of these things are on blogs, there's numerous references in the deposition to something called the Orange Park Hub, which was where everybody in Orange Park would sort of meet online to discuss, among other things, this project, which is why, and I'll get to it in a little bit, why I believe the statute, anti-SLAPP statute, comes into play. If she had gone on record as saying something like, I know he has taken cash in a brown bag or something along those lines.
Well, let me ask you the question this way. What did she mean?
She repeatedly said, and this is actually in her deposition, I'm a U.S. citizen, I get to ask questions, what's going
Understand
on?
that. In your opinion, what did the appellee statements mean to convey regarding the appellant's conduct?
Well, what she
It
said,
certainly wasn't, well, he should have required more stormwater storage, right?
no, sir, it wasn't,
It
had
certainly
nothing to do with
wasn't,
drainage
there should
or
have been more
anything.
parking spaces required, right?
No.
So it wasn't, none of it went to the merits of the project, right?
It went to the merits of the project.
No,
I
it
think.
went to his motivation, right?
No, I think it actually also went to the merits of the project, as in, do we need this? For example, the project was played up as having great tax benefits. There were questions over that. You know, the merits of the project do not necessarily end with the horizontal improvements and vertical improvements of the project. This goes to the merits of the project as into whether it is in fact necessary, whether it is needed. I think, with the court's permission, I believe it would be unnecessarily narrowing the scope of the inquiry to say it only goes to what the bulldozers and pipe layers do.
Right. So I'm sorry, and I kind of interrupted you. You
No,
were
not at all,
answering
sir.
about the hypothetical, but again, I'm not sure I heard an answer to
Okay.
what were the purposes of her comments.
She was-
Looking at it in an overarching manner, was she criticizing the appellant on the basis of the merits of the project, or was she questioning whether or not his motives were improper?
I believe she was questioning the merits of the project and as, why is this happening so fast? Why is it being pushed through?
And what do you think is a reasonable inference to that comment?
Well, let me say this, the reasonable inference is subjective, and I would imagine, and different people might think, well, is it reasonable that, what is she saying, he's getting the proverbial brown bag full of cash? Or is she just tired of him working seemingly hand in glove going to
So
lenders?
is it your view under New York Times versus Sullivan that a citizen can simply imply that a person is acting, not saying that your client did, but hypothetically, can a citizen suggest that a public official is acting on the basis of an improper consideration? And again, could be your client, could be the media, questioning whether a public official is acting on the basis of bribery or some other nefarious motive with no evidence. Is that proper even under New York Times versus Sullivan?
Well, when one thinks of the language, it says the need to investigate is not required. And I don't want to say that makes everything just a Wild West show. But if I were to try to categorize and then put my client's language and put it in terms of the case, I would say she fell far short of anything that would be actionable under New York Times v. Sullivan.
Again, I'm not speaking of your client, but we're just looking at it from a rule of law
Of course, sir.
perspective. Can a citizen just say that, does a citizen have to say, I think Judge so-and-so, County Commissioner so-and-so, Governor so-and-so, this could be the media, by the way, which, often is involved in some of these kind of cases,
Many
is
of them.
accepting a bribe. So do they have to specifically say that, or under New York Times versus Sullivan, or can an implication of that be sufficient for a libel or slander suit?
I am very hesitant to talk about implications being sufficient, and this is why. As Judge Roberts has said, you go to a meeting, and I've attended meetings sometimes as an attorney, and not of the town council in Orange Park, that's not my bailiwick, but I've attended tax valuation meetings, Board of Ed meetings, and so forth. And, you could hear somebody, a citizen, say something like, what is going on here? What are you people doing? Why are you doing this? What are you getting out of it, type of thing? If that person then, so one might say, of course, well, that was before the board. What if they go outside and they're out on the street here in the parking lot and they say it? It is still not actionable. It is annoying. It may be maddening to some people, to some politicians. I don't think I need to go into Truman's line about stay out of the kitchen if you don't like the heat. But there is a certain, it's not like how we as lawyers have to put up with lawyer jokes at parties on a Saturday night. there's a certain number of maddening things which occur by virtue of the position we hold and the life we choose.
So public officials, and again, just to shift the debate so it's not particularly about your client.
Yes, sir.
Let's say it's about a media outlet. So a public official has to be willing to accept lies from media outlet that accuse public officials of criminal conduct falsely?
The story of the
Is
question
that
is,
part of the bargain for being a public official?
the question is what was said. If what was said was something that is somebody, I hate to say it, I've heard parties say about a judge, why did he do that? And I've had to talk clients down
Right.
when they say, does he know somebody? Does he know? No. He just disagrees with you. That's all. And if I had to tell that person, hey, don't, if there was a third person here and you broke the privilege plane, that would be actionable. I'd have to start wondering, do I now control thoughts? Do I somehow control his thoughts? No, people say things. They ask questions. It's not, there's an enormous gulf. There's a gulf, this chasm between somebody saying, I saw somebody slide a bag of money to him, and saying, God, why is he working with a developer like that? There are degrees. And this, what my client said, at worst, is so far over to one side as to keep as to warrant the summary judgment standing.
Yeah, well,
Because-
let's pull it back into the specific facts of this case.
Yes, of course.
In response to the summary judgment, appellant filed 2 affidavits. That's it, is my understanding. I can't tell, or it's not clear to me from the judge's order, were those considered or were they not? I know they were filed over objection.
Yes, they were filed over objection. I made sure I objected to them because they were clearly objectionable. And I believe I have the final judgment. I believe it says that further considerations might be, defendants' objections of affidavits offered by plaintiff are overruled as moot. That was in, so, overruled, moot, one might say that's 2 different things. Maybe just disregarded because they're moot, but it says overruled because there is moot, they were moot. But those objections, and I'm prepared to argue those objections, were well-founded. Those affidavits were totally insufficient to stop a summary judgment. They were based on statements such as, to the best of my knowledge, things were said in a derogatory fashion, I believe. One of the affidavits said something about on the take, et cetera, as statements by other people. That's why I filed the objection, because I didn't want that going on the record as being without an objection. There was nothing in those 3. There were actually 3 affidavits. Mr. Mastandreas and 2 other folks who are non-parties, and all of them had the same shortcomings. They would not, none of them would have been even, none of them contained evidence that would have been admissible at trial. Nothing was, I don't even think the words personal knowledge were used in most of them. They weren't, they were all on, not information and belief, but I believe, something along, I have them right here.
While you're looking at that, I'll ask you another question.
Of course.
And that is, I assume your argument is, and obviously it is, that even if your client doesn't prevail under the anti-SLAPP statute, under New York Times versus Sullivan, everything your client said was not actionable.
That's correct, sir, and I stressed that in the brief, and I stressed that in the court below, that they're not tied to each other. I believe the court was correct on both, but the summary judgment stands on its own. With regard, I'm showing time running out, so the affidavits had language such as, I affirm to the best of my knowledge, I have been instructed, I understand, I hereby affirm to the best of my knowledge. Nobody just put the ball over the goal line. If you know it, say it. But they didn't have it in personal knowledge because the things weren't said. That's why nobody could say that they were said, because they weren't said. And that's why, well, my time is up.
I'll allow you to briefly conclude.
Okay. I believe the statute is applicable. With the court's permission, I could run through the provisions of the statute and tell you why I believe that. When we go into the definitions, first of all, the intent of the legislature to protect the right in Florida to exercise the rights of free speech in connection with public issues. And the public policy, this is all in 768.295. Definitions, when it talks about free speech in connection with
Judge,
public issues.
is it your view that under the anti-SLAPP statute, a statement that would otherwise be actionable as libel or slander cannot be filed no matter whether there was reckless indifference to the truth?
Your Honor, there is the one case, the Materio case, which I cited, which does say that since the suit below was without merit, there...
No, I'm saying a hypothetical where a media outlet or a citizen makes a false statement with reckless disregard for the truth. If that were part of a SLAPP context, is that prohibited under the statute, that libel action?
Well, I think we'd have to take one, let me answer that this way. We'd have to take one step back, because the statute says a suit brought without merit, so that would go to the question of was there without merit, and primarily because such person or entity has exercised the constitutional right of free speech in connection with a public issue. Clearly, it's a public issue.
And since under New York Times versus Sullivan, it's almost impossible for a public figure to file a libel action with merit, then it would be barred by the SLAPP statute, would be your argument, right?
Yes, sir, and I'm reading from the statute. It's not, I'm not implying,
Right.
I'm going
I
with,
understand.
I'm playing with the rule book the legislature gave me.
I understand. I'll allow you now to very briefly conclude.
Your Honor, Your Honors, the summary judgment itself was proper under both the federal case, of course, and the constitutional provisions, and Florida law, clearly by the cases I cited. And it was within the protection of the anti-SLAPP statute. This statute, I will end with this. I read a description of what a anti-SLAPP case was. It was from a case up north somewhere in Illinois or Indiana, and it said basically an anti-SLAPP suit is a suit brought by a developer against somebody who is complaining that they don't like the project. And I thought, wow, well, that rings a bell. And this is clearly within that statute, and I believe the judgment should be affirmed in full. Thank you very much.
Counselor. I would ask the clerk to award an additional 2 minutes and 50 seconds to the appellant's time, please. Thank you.
Thank you.
Just to address a couple of the points on rebuttal. Your Honor, the developer's project was not my client's pet project. It was simply a project that he was enthusiastic about as a representative of the town, and he felt that by supporting that kind of a project, the town would benefit, including all of its citizens, property owners, et cetera. So again, it's the same kind of issue. With regard to the cease and desist letter that came from my office with the identical language in the body of the letter, with the exception of the names, as you will note, most of the language addressing any of the facts can be interpreted as colloquialism, and that's what that was intended to mean. Now, the rest of the body of the letter includes simply a recitation of the law in order to provide individuals with an understanding of what those standards were with regard to them, and nothing more.
Yeah, I'll ask you this question that I asked your opponent. In the McKee case, there are 2 dissents from the denial of certiorari in that case, one by Justice Thomas and another one by Justice Gorsuch. That case involved a woman who alleged that Bill Cosby raped her. And the lower courts had ruled that by merely coming forward with her complaint, she had rendered herself into a public servant, a public figure, and therefore was subjected to the almost impossible burden legally of New York Times versus Sullivan. And Justice Gorsuch cited statistics as to how it is essentially almost impossible for a person to sue the media under New York Times versus Sullivan even where the statements are patently false. And he cites very ominous statistics there about how few libel and defamation cases can survive New York Times versus Sullivan. Given that, it's almost impossible to meet the court-created standard of New York Times versus Sullivan. Under the anti-SLAPP statute, since it's almost impossible to file a libel suit by a public figure, then those cases can never have merit, right?
Well, Your Honor, I think that you are addressing a very important issue, and that is government by the people for the people, and that nobody should have an absolute immunity. And so if automatically filing a lawsuit of defamation by a public figure, and they have to adhere to the standard of actual malice, and a dismissal at summary judgment is interpreted as a lawsuit having filed non-meritoriously, then you're absolutely right. Now the citizen has absolute immunity.
But that's the conundrum we're in here, isn't it?
It is. However, I believe that there are some limitations, and the limitations really come out of, I enjoyed this case. It was a Perk versus Reader's Digest Association, 931, F2D 408, 411, Sixth Circuit, 1991. It is persuasive. However, in that case, it was ruled that a plaintiff can present proof of malice in the form of cumulative circumstantial evidence, which is often the only way to prove malice in a libel case. That's why we had to take depositions at this type of length, because we had to get into the mind of the appellee in order to find out, is this person just throwing statements out there without any consideration? Does she actually believe what she's saying, or does she just not care what she's saying? And I think that the evidence shows that she just didn't care what she was saying. She didn't bother to follow up. And with regard to the standard in Sullivan, Your Honor, there has been some development in Hark T. Hanks Communication, Inc. versus Connaughton, 491 U.S. 657, 1989. The court stated that actual malice was found where the defendant declined to interview a particular witness,
Right.
which this appellee did, who could have verified the story, which would have been provided had she cared, and actually declined, and where an earlier article in that case, an earlier article by the defendant showed that it had already committed itself to attacking the plaintiff. In this particular case, if we look at the cumulative evidence, we can find that there
Right,
was
and in that case, which involved a newspaper's allegations that a judicial candidate had engaged in dirty tricks, the candidate won the libel judgment, and it was affirmed by the Sixth Circuit and the United States Supreme Court, correct?
Yes, Your Honor. And
And it went to trial.
It went to trial. And in this case, we have, for example, the Orange Park Hub, which is arguably a platform created on Facebook for the purpose of defaming my client. It's being couched as opinion, but it was an attack on my client. Now, Your Honor, if I may, well,
So does it make any difference whether Ms. Snow is, if she were a reporter from the New York Times, who their job is to go out and interview people and find facts, or just a private citizen who attends the meeting and then expresses their conclusion from what they saw at the meeting?
oh, that's an interesting question. But I think that what ends up happening is that I think the relevant response to your question, Your Honor, would be based on the application of the anti-SLAPP statute, and whether the anti-SLAPP statute could be applied in defense by a public figure if the public figure is sued. So, for example, a newspaper reporter that is being sued by a public figure would still have the defense of actual malice.
Well,
That's a tough question.
I'm gonna have to ask you to very quickly conclude.
Yes, Your Honor. I think ultimately the case provides for a very long record. I think that the depositions really do dive into demonstrating the state of mind that the appellee was in, that there was a targeted approach and intent to defame my client, that there were accusations of criminal conduct that were implied, and my client simply decided, hey, you know what? I value my reputation.
Thank you.
Thank you, Your Honor.
Thank you, Counselor. We'll allow the lawyers to step down briefly and then proceed to the second case. Thank you both for your arguments.